You make promises every single day, right? Some are tiny, some are huge, but what's the difference between a casual promise and one that the law will actually enforce? Well, for that, you need a rulebook, and that rulebook is what we call a contract. Today, we're going to deconstruct that rulebook by looking at a really cool real-world example that shows us exactly how these official promises are built.
Our guide for this is going to be the official Contract Act of Bhutan from 2013. Now, don't worry, you are not going to need a law degree for this, I promise. The principles we're going to talk about are pretty much universal. They're the same fundamental building blocks that you'll find in contracts all over the world. This act just gives us a perfect blueprint for how a simple idea or a handshake evolves into a deal that legally has to be honored.
So here's how we're going to trace the life of a promise in 5 stages. First, we'll talk about why we even need a rulebook for promises. Then we'll get into the anatomy of a deal. What are the essential ingredients? We'll also figure out who can legally make a promise in the first place. And then we'll look for the red flags, the deal breakers, that can make the whole thing fall apart. And finally, we'll get to the finish line, what it really means to keep your word.
Okay, so first things first. Why do we even have these complicated legal documents? It's not just to make things more difficult. It's really about creating a system that's fair, that's predictable, and most importantly, protects everyone who's involved in an agreement.
This quote from the very beginning of the Act really gets to the heart of it. The whole point is to consolidate and codify practices. That's just a fancy way of saying, let's take all the unwritten rules and customs and actually write them down. That way, everyone is playing by the same game plan. And the ultimate goal? To ensure the rights of the people. This is the safety net that makes our agreements mean something.
All right, think of a contract like a recipe for a cake. If you leave out a key ingredient, like the flour or the eggs, you don't get a cake, you just get a mess. A deal is kind of the same. And the Bhutan Contract Act lays out these essential ingredients for us, step by step.
The journey from just an idea to a full-blown contract follows this really clear path. It all kicks off with a proposal. Once someone accepts that proposal, boom, it becomes a promise. And when you have promises being exchanged, you've got yourself an agreement. But the real magic, the final step, is when that agreement becomes legally enforceable. That is the moment it truly becomes a contract.
So ingredient number 1 is the proposal. And this isn't just a casual, hey, what if kind of chat. This is a formal offer. It's one person saying to another, here is the deal and I'm ready to be bound by it if you say yes. This is the official starting gun for any contract.
Next up, we have acceptance. And this part is super strict. The Act says acceptance has to be absolute and unconditional. You can't say, sure, I'll buy your car, but you have to throw in new tires. As soon as you add that but, it's not an acceptance anymore. It's actually a brand new proposal, what lawyers call a counteroffer. To seal the deal, you have to agree to the exact terms that were put on the table.
Now, for a word that sounds a little intimidating, consideration. But honestly, it's pretty simple. It's basically the what's in it for me for both sides of the deal. It's what each person gives and what each person gets. It could be money for a service or work for a salary. It can even be a promise not to do something. The key is that there has to be a two-way exchange of value. Without it, a promise is just a one-sided gift, not a contract. Okay, so we've got our recipe for the deal, but the ingredients are only half the story. Just as important is who's making the deal. See, not everyone has the legal ability to lock themselves into a binding promise. The law is really clear about who is considered competent to make a contract. Section 20 of the Act lays out 3 very clear conditions. First, you have to be of legal age. Simple enough. Second, you have to be of sound mind, which basically means you understand what you're doing. And third, you can't be disqualified for some other legal reason. These 3 checks are there to make sure that the people making the promise are actually capable of making it. Let's zoom in on that sound mind requirement for a sec. This is all about comprehension. The law is asking a very specific question. At the exact moment you made the agreement, did you understand what it meant? Did you get the consequences? It's basically a snapshot of your mental state to make sure you could make a rational call about what was best for you.
And now we get to the dramatic part of our journey, the deal breakers. Sometimes a promise looks totally fine on the surface, but there are these hidden problems that can cause the whole thing to just fall apart. These are the critical red flags that the law is designed to catch. And this brings us to probably the most important question of all. What if you didn't really agree? A contract is supposed to be built on mutual agreement, right? But what if that agreement wasn't genuine? What if you were pressured, or tricked, or flat out lied to? This is where the whole idea of free consent becomes absolutely crucial.
The Act lists 4 major deal breakers here. Coercion is being forced into it. Undue influence is when someone you trust or who has power over you manipulates you. Fraud is, well, being intentionally deceived, and misrepresentation is being given false info. If your yes was the result of any of these, the law says the contract is voidable, and that means you, the person who is wronged, get to decide whether to cancel the whole thing.
This brings us to a really important legal difference: void versus voidable. A void agreement was never a real contract to begin with. Think of it like an agreement to do something impossible, like flapping your arms and flying to the moon. It was invalid from the start. A voidable contract, though, is different. It's a valid contract that has a fatal flaw, like that lack of free consent we just talked about. This shifts all the power to the person who was wronged. They get to decide whether to enforce the contract or just walk away.
And then, there are some promises the law just won't touch, because their whole purpose is illegal or harmful. I mean, you can't make a valid contract to commit a crime, right? Or to defraud someone, or do something that's against the public good. In these cases, the law just says, nope, these agreements are totally void from the very beginning.
So, we've built our contract, we've checked out the people involved, we've scanned for all the red flags. Now we've reached the finish line of our journey, the moment of truth, where the promise actually has to be kept.
And here is the payoff. The Act makes it crystal clear. The parties must perform their obligations. This is the entire point of the whole journey we've been on. This is where a simple promise finally becomes a legal duty, and it's a duty that the law is ready to enforce.
And that brings us full circle, right back to that quote from the beginning. The entire legal machine we've just explored, from proposals and acceptance all the way to the rules on consent, it all serves this one powerful goal: to protect our rights and make sure that when a promise is made, it can actually be trusted.
So, the next time you buy a coffee, or click that I agree button on a website, or even just tap your card to get on a bus, remember this hidden rulebook that's governing the whole thing. You're navigating a world that's literally built on promises. It kind of makes you wonder, doesn't it? How many contracts did you enter into today without even realizing it?